welcome to our webinar. My name is Leah, and I'm the Knowledge Exchange Coordinator here at Women's Shelters Canada. I'll be moderating today's webinar, and I'm really excited for it. I think it's going to be really informative, really helpful, and hopefully there'll be lots of questions, really interactive. So I want to start before going further by acknowledging that I'm joining you today from the traditional unceded territories of the Algonquin and Anishinaabe people. And I know the beauty of the remote format, we have people joining us from across Turtle Island today. And so I do encourage you to let us know where you're joining from, say hi in the chat. And if you don't know what territory you're on, then this can be a gentle prompt to look that up and learn a little bit more. So a few housekeeping reminders before we get into it. Today's present just about interpretation, one last reminder here. If you are hoping to listen in English, you don't need to turn your interpretation on. Pour celles qui veulent l'audio en français, veuillez cliquer sur le bouton Interprétation en dessous de votre écran et sélectionner French ou Français pour écouter en français. So for those listening in French, you can activate your interpretation at the bottom of the screen. And if you do have any technical issues with that throughout, just let me know in the chat and I will do my best to respond to them. And hopefully it'll go smoothly for folks. So you might have noticed by now that your video and your audio are off. We have just the panelists online today with their video and audio, just because we have, well over 100 people here. It helps us make sure the audio quality is good for everyone, but it doesn't mean we don't want your participation. We definitely do. And so there are two really great ways you can participate today. One of them is the chat, which some of you are using already. So just a reminder, you can set your chat to all panelists and attendees in the two line there if you want everyone to see your message. If you're saying hi or you have a comment or something like that. If you just want the panelists like myself to see it, you can, like a tech question, for example, you can just leave it to all panelists. The other way you can participate is the Q&A box, which you'll see at the bottom of your screen right beside the chat. And that's where you can put the questions that you have for Pamela, for our speaker, who's going to be presenting shortly. And that's a really great way for us to kind of manage the questions a little bit better and keep track of them and get to as many as possible. So please use the Q&A for your questions, use the chat to say hi for comments, things like that. And I see a question already, which is a great question about whether you'll be receiving handouts by email. So you will receive a copy of the PowerPoint presentation afterwards. We have a copy in English and a copy in French we'll send around, as well as a copy of the recording of today's webinar. And yeah, so without further ado, I'll get right into it. And as you know, today we're talking about the changes to the Divorce Act that are taking effect very soon on March 1st. And I'm super excited. We have Pamela Cross with us today. And she's going to really dig into those changes, how they'll affect your work with survivors, and have lots more to say. So I'll let her get to that in just a minute. Pamela is the legal director at Luke's Place in Ontario, a feminist lawyer and a respected expert on violence against women and the law. And we're really thrilled to have her with us today. So just before passing it over to Pamela, we do have a little bit of a poll here that I've just popped up on your screen there. And it's just for us to get a better sense of who's with us today, and what your comfort level is with the subject matter. So it should pop right up on your screen. You can take a few seconds to answer. We're asking where you're joining us from, province or territory. And my apologies to the folks in the Atlantic and the territories. It would only let me put in 10 answers. So I had to combine several provinces. So sorry about that. Wondering what your role is within your shelter and how you would rate your current understanding of the Divorce Act, the changes to the Divorce Act, which will give Pam a great sense of who's with us. So quite a few of you have voted. I'm just going to give it another 10 seconds or so for folks to weigh in. Great. So I'm going to end that poll and I'll share the results with everyone. So hopefully you can see that on your screen. We have quite a large Ontario contingent, lots of folks from Quebec, but people from all across the country. So that's really great to see everyone. Lots of frontline workers here, 68% of you. That's also really great. And I know Pam will be speaking kind of directly to some of the ways this will affect your work. And a really good kind of, most of you sort of in that some understanding, minimal understanding of the changes. So that's great. Hopefully this will be a really informative session for everyone. So without further ado, Pam, I'll pass it over to you.
Thank you very much, Leah. I'm just going to get my slides up here now. And okay. Every time it's like I've never done it before, but I think they're up there now. So thank you, Leah, and thank you to so many of you for taking time out of your busy schedule to join us this afternoon. I'm really happy to be here with you to talk about changes to the Divorce Act, which, as Leah said, come into effect very soon. In fact, on Monday, March the 1st. Let me begin by acknowledging that the land from which I'm speaking to you is the traditional territory of the Huron-Wendat, Anishinaabeg, and Haudenosaunee peoples, whose presence endures here. I want to just very briefly tell you a little bit about Luke's Place so that you understand the context and the perspective that I bring to what I'll be talking with you about today. At Luke's Place, we provide direct services for women in Durham Region. And for those of you who don't live in Southern Ontario, Durham Region is just east of the Greater Toronto Area. We work with women there who have left abusive relationships and who are engaged with family court and family law. We bring a team approach to this work in which women work with their own legal support worker, as well as pro bono lawyers who offer their time to us. Ontario has a program called the Family Court Support Worker Program, which offers free family court support to survivors of family violence. And that was modeled on the legal support worker program that we developed at Luke's Place. We also work at the provincial and national levels, conducting research, developing resources, providing training, and engaging in systemic advocacy. And down the right-hand side of the slide, you can see our 3 websites. So if you're interested in learning anything more about what we do, please have a look at any of those websites. The top one, Family Court and Beyond, is a resource intended to assist women directly as they're involved in a family court case. And I also put my own website at the bottom, just in case you're interested in knowing any more about me. This afternoon, we're going to look at the Divorce Act. I'm going to start by telling you generally how family laws in Canada operate. I'll then give you an overview of the history of attempts to change the Divorce Act. Then we'll explore in detail the changes coming into effect on Monday that are related to how parents will make post-separation arrangements for their kids. In the context of family violence situations, primarily. I'm also going to give you a bit of a critique of where I think the changes got it right and where I think there are still some problems. Again, all through the lens of women who are leaving abusive relationships. As I look at the new provisions in the Divorce Act, I'm going to make some suggestions for you about how you can assist women make the best use of those changes in terms of how they present evidence and their case, their story in family court. Although I'll refer occasionally to provincial and territorial custody and access laws, that's not the focus of what we're talking about this afternoon. And I'll mostly refer to them as they're similar to or different from the federal law, the Divorce Act. We're going to take as many questions as we can. So just to reiterate what Leah said, as a question comes up, before you can forget it, jot it down in the chat or in the Q&A. I'll stop periodically and Leah will summarize at least some of the questions that are there. We do have a limited amount of time, but Leah is going to somehow, I don't know how this works, save anything in the chat or in the Q&A that we don't get to, email it to me, and I will produce answers to those questions, and then Leah will send them out to all of you. Hopefully I can do that within the next few days, and then she'll get it out to you as soon as she can after that. I've tried to build my presentation so we also have some time at the end where we can try to get through any questions that have piled up. Before I go any farther, because I'm a lawyer, I have to give you a disclaimer. This webinar is not to be interpreted as legal advice because it's not. It should not be used as legal advice. It's legal information that's related to changes in Canada's Divorce Act. Only a lawyer can provide legal advice once they've been retained and once the client has told them all of the details of their situation. The information I'm sharing with you today is current to the date of this presentation. So if something changes between today and March 1st or after March 1st, once the legislation comes into effect, that's on you to find that information and make sure that you're up to date. It's unlikely that's going to happen, but just to be clear, the information is correct as of today. So let's start by looking at what the Divorce Act is. It's a federal law. That means it applies to people wherever they live in Canada. It's the law through which people who are married can end their marriage with a divorce. It also covers what lawyers call corollary issues. Arrangements for children, which up until now has been called custody and access, property division, and support. It doesn't matter where you live in Canada. It doesn't matter where you got married. As long as your marriage was legal in the place where you got married, you can use the Divorce Act to apply for a divorce in Canada. So for instance, if I got married in British Columbia and now I live in Ontario, even if my spouse still lives in British Columbia or maybe lives in the United States or Chile or anywhere, I can apply through the Divorce Act from where I live in Ontario for a divorce. If I got married in a country where polygamy is legal and I got entered into a polygamous marriage and then my spouse and I moved to Canada, even though polygamy is illegal in Canada, because it was legal where I got married, I can apply for a divorce under the law in Canada, under the Divorce Act. The Divorce Act does not cover everything that can come up in a relationship where there's been abuse. You'll notice when I said the corollary issues, I only listed arrangements for kids, property division, and child and spousal support. You can't get, as in you cannot get, a restraining order or a protection order through the Divorce Act. You also cannot get an order for what's called exclusive possession of the matrimonial home. So the Divorce Act is really about divorce, and they've kind of thrown in these few other issues, kids, property, money, but it doesn't address every issue that comes up when a relationship breaks down. That's where we have to look to provincial and territorial laws. All provinces and territories have legislation dealing with family law issues. Those laws cannot give somebody a divorce, but they can help people resolve other family law issues. Arrangements for children, child support, spousal support, division of property, restraining or protection orders, and exclusive possession of the matrimonial home. In some provinces and territories, all of those legal issues are covered in one statute. In others, there's more than one law that deals with family law issues. For instance, in Ontario, where I live, the Children's Law Reform Act governs child-related issues, most significantly parenting arrangements and child support. The Family Law Act of Ontario addresses spousal support, property division, restraining orders, and exclusive possession of the home orders. So you'll be more familiar with how your province handles the family law at the provincial level than I will. I know a lot about the Divorce Act, and I know a lot about the provincial laws of Ontario. So let me say one other thing about how provincial and territorial laws operate. As I said, they're for the people who live in those provinces or territories. But we have to also understand the concept of habitual residence. Habitual residence is where the family was living at the time of separation. If I live in Ontario with my partner, married or not married, and we have a couple of kids, I'll just say we live where I live, Kingston, and we separate, and I immediately move to Toronto with the kids because that's where my family lives, their habitual residence is Kingston. And if I'm going to go to court to get an order about the arrangements for the children, I need to start that family law case in Kingston. The same is true if I move not just to Toronto, but to another province or even to another country. Likewise, if we were living, let's say, as a family in Manitoba, and we moved to British Columbia because either my partner or I got a job there, and almost immediately upon getting to British Columbia, our relationship broke down and whoever was with the children moved back to Manitoba, there would be a very interesting issue about where the children's habitual residence was, because while they were actually living in British Columbia when the family breakdown happened, they'd maybe only been there for a few weeks or a few months, and they had lived all of their lives up until then in Manitoba. So if I'm the parent who's taken them back to Manitoba, I'm going to try to argue that Manitoba is their habitual residence. My partner out in BC might be trying to argue that it's British Columbia because they would prefer the court case to happen where they're living. So when you're working with women who come into your shelter, say, I'm sure you ask this question anyway, but it's certainly important to clarify whether they have lived in your province or your community prior to the time that they separated. If there's going to be a family law case, that could be very important information for them to be aware of, and for you if you're assisting them in any way with that. As you'll see, the changes to the Divorce Act will create some differences between federal and some provincial and territorial laws with respect to language and to the approach for resolving issues related to children. And this is a real flaw in Canada, where we have one system of laws at the federal level, the Divorce Act, that only people who are married can use. Everyone else uses provincial laws, and they're not the same. So there is a difference and inequality in terms of access to justice for people depending on their marital status and where they live in Canada. There were significant changes to the Divorce Act. We're going to focus on the changes that relate to children, but I want you to be aware that there were a significant number of changes made. There are changes made of a jurisdictional nature, changes made to what the process is if the parent wants to move with the children or relocate with the children. Child support orders are going to be enforced differently, slightly differently. Legal advisors, which is what lawyers are being called now, apparently, have new duties. There is a real focus on encouraging people to use alternate dispute resolution, by which I mean primarily mediation, and so on. But what we're going to focus on today are the changes to language, the definition of family violence, which is new, and the best interest of the child test, which is also new. These revisions, while they're not perfect, address many of the concerns and issues that have been raised over the past 2 decades by women's equality advocates. As you can see in the purple oval there, the new Divorce Act has not introduced a presumption in favor of shared parenting. We were very concerned about this. It's something that fathers' rights individuals and organizations have lobbied hard for more than 20 years. But this government has chosen not to move in that direction, and we're extremely grateful for that. Any of you who aren't experts in family law, let me explain what this means. A legal presumption means it's the starting point. So if there were a legal presumption in favor of shared parenting written into the Divorce Act, that would mean that the default arrangement for kids would be that they were shared, their time and decision-making was shared equally between the parents. And if either parent didn't want that arrangement, they would have to prove why that was not in the best interest of the children. So you can see why we would not have wanted this kind of a presumption, especially in cases where there's been a history of family violence. When the amendments to the bill were introduced in 2017, a national coalition of women's organizations, which included some of you, came together under the guidance of NAL, the National Association of Women in the Law, and Luke's Place to engage with the federal government as it worked on those revisions. If you're interested in learning more about what we said to the Department of Justice, you can check out the brief that we submitted. The link to it's at the bottom of this slide. And as Leah has said, you will be getting those slides after the webinar is over. So let's dig in. Let's start by looking at this new language. The old Divorce Act, and this is true for many of the provincial and territorial statutes as well, used the language of custody and access to refer to the arrangements that parents make for their children after the parents separate. In legal terms, custody refers to decision-making responsibility, although it also often means that that parent has primary responsibility for the physical care of the children. Access is the time kids spend with the other parent, the parent they aren't spending most of their time with. And that access can be formal. So the order could say the children spend time with the father every other weekend, beginning at this time on Friday, ending at this time on Sunday. It can be informal. The children will spend time with the father as the parents arrange. It can be unsupervised, which is the most common, or it can be supervised. The exchanges can also be supervised. So where there's a concern that it's not safe for the children to be alone with the father, or a concern that the father might not return the children at the end of the visit, then the access itself can be supervised. That supervision can be informal with a family member or a friend, or formal. Most parts of the country, most urban parts of the country have official supervised access centers. But it may be that it's fine for the kids to be alone with their dad. It's just not safe for the mother and father to exchange the children directly. It's not safe for the mother, in which case the exchanges can be supervised. And I'm sure all of you have seen the impact of the pandemic on those supervised exchanges and supervised access, because of course, most of those centers have been closed, either for part or all of the past year because of COVID-19. So we've seen a real crisis. We've seen an increase in calls, significant increase in calls from women to us at Luke's Place as they're trying to sort out how they're supposed to make sure their kids still see the father when the supervised center where those visits were taking place is no longer available. Sole custody means that one parent gets to make all of the decisions, except one, without consulting with the other parent. If I have sole custody of my kids, I can decide what religion I want to raise them in. I can decide what kind of education I want them to have. I can decide where we spend summer vacation, but I can't move. I cannot move with those children without either the consent of my former partner or an order from the court. However, for all intents and purposes, I get to make all of the decisions. Where there's joint custody, the parents must consult with one another about decisions relating to the children. And I'm sure I don't have to tell anybody on this call that joint custody is highly problematic in situations of family violence, because the abuser manipulates that role as a co-decision maker for his own purposes. His focus is not on what's best for the children, but on his desire to maintain power and control over his partner. And we're going to come back to that in just a minute when we look at the wording in the new Divorce Act. So these are terms people are pretty familiar with. They've been around for a long time. They're used not just across Canada, but in many parts of the world. However, they are terms that are seen by some to be adversarial, to create a win-lose situation. And so they're gone. When the Divorce Act comes into effect on Monday, custody and access are gone, never to be heard again, although I suspect we will in fact continue to see them popping up in orders for some time. The new language contains the terms parenting order, contact order, decision-making responsibility, and parenting time. And I'm going to take us through what each of those terms means. Contact order, brand new concept in the Divorce Act. This is the term that will describe the time a child spends with someone other than their parents. This will be most commonly grandparents, but it doesn't have to be grandparents. It could be another member of the extended family. It could even be a close friend of the family. Grandparent rights are entrenched in some provincial and territorial family laws, but until now, they have not been set out in federal law. So it is a new concept. The kind of situation where this is likely to come up, because it's in the Divorce Act, so someone has to be getting divorced, is this. The two parents are divorcing. There's been a history of family violence. The mother wishes to limit the father's access to the children, perhaps to supervised access. And she's concerned about the children seeing his parents, the paternal grandparents, because they have really enabled the father's abuse of her. They are in denial about the fact that he's been abusing his partner. And she's worried that if the children can see those grandparents, they will badmouth her. They will continue to deny their son's responsibility for the abuse that's happened in the relationship. In that case, the grandparents could bring their own court case to get a contact order so that they could see the children, their grandchildren. That order would set out the time that the child spends with this person other than their parent, both physically or by telephone, Zoom, Skype, email, snail mail, anything like that. As with all decisions relating to children, the court must apply the best interests of the child test, which we're going to talk about in a few minutes, when it decides whether a child should spend time with a grandparent or another person. Decision-making responsibility. So this is the very long word compared to the word custody of the old legislation. And this is the area that I think I'm the most critical of in terms of where the Divorce Act went. So let me explain what it says and then tell you why I think it's a problem. This is the term that describes who gets to make decisions about the children. The parent with decision-making responsibility has the authority to make the significant decisions about the child's life and well-being, including decisions related to four, I guess I'll call them pillars or categories of the child's life: health, education, culture, language, religion, spirituality. That's all one. Culture, language, religion, and spirituality, and significant extracurricular activities. In other words, pretty much everything that happens in a child's life. That responsibility for making those decisions can be given to one parent, so think about the old language, sole custody, or shared between the two parents, joint custody. However, the Divorce Act also says whichever parent the child is with at a given time has the authority to make decisions during that time. Of course, the intention of that language is to enable the parent the kid is with to make decisions about minor issues that come up, or in the event of some kind of emergency. My children are with me for the weekend. Their other parent has primary decision-making responsibility. They've gone away for the weekend, and I have to make a decision on the spur of the moment. Do I let this 12-year-old go to the movies with their friends? That makes sense. Or I'm at soccer with one of the children. They're injured. We go to the hospital. Turns out they have a broken ankle. I can't get a hold of the other parent. I get to make the decision in that instance about what should happen. All of that makes sense. The problem with the way it's written in the Divorce Act is that it doesn't say that. It just says the parent has the authority to make decisions during that time. And you know as well as I know that an abuser is going to use that provision to say, oh, the child's with me this weekend. I'm not going to take them to their swimming lesson. Or I think this medication that the child is taking for ADHD or whatever it is stupid. I'm not going to give the child this medication. Or I don't care that my former partner, the other parent who has primary decision-making responsibility, has chosen not to raise the children within an organized religion. I'm going to take them and get them very involved in my religious community. I ran into this a lot when I had a law practice, and we see it frequently at Luke's Place, where the parent, it's usually the mother, who has the children most of the time and who has the legal authority to make, as the new legislation says, the significant decisions about the child's life, finds herself in a situation where her former partner, who was abusive to her, slips through that little crack and says, oh, the kids are with me, that means I get to make decisions. And they are making those decisions not thinking about what's best for the kids, but thinking about their desire to maintain power and control over their former partner. Unfortunately, the new Divorce Act missed a real opportunity to be clear that day-to-day decisions made by the non-primary parent cannot conflict or interfere with the primary parent's decisions. It would have been a very simple sentence to put in there, and unfortunately, they didn't put it in there. So let me now just tell you about one other language piece, and then we'll take a few minutes and see if there are any questions that relate to what we've talked about so far. So gone are custody orders or access orders. Instead, we have parenting orders, and a parenting order assigns parenting time and decision-making responsibility. Parenting time is the time the child spends in the care of each parent, including time they're not physically with that person. What does that mean? That means that if my parenting order says I have parenting time from Monday at 8 a.m. until Friday at 4 p.m., and they spend Friday at 4 p.m. till Monday at 9 a.m. with their other parent, then even when they're not with me, when they're at school, I'm the parent who has the parenting time. If there's a problem at school, if the school has to close down, if there's a snow day, if there's a pandemic for a year, I'm the person who's responsible for the child, for decision-making, for being contacted by the school, and for making arrangements during that time. And you might think that's obvious. It is obvious. But I can tell you that in the early to mid 90s, and this was when I had a law practice, I had more than one case where the abusive former partner of my client would sit down and work out to the minute how much of the time when the children were with the mother, they were doing something other than being physically with the mother, and would try to argue that that meant that she didn't really spend that much time with the kids, therefore he shouldn't have to pay so much child support. So I think this is a bit of a preemptive strike to try to stop that from happening. You can see from this slide that now there's no distinction between custodial and access time. It's all called parenting time. And I think that's going to be terrifically confusing for a while. Even a parent who sees the child only for 2 or 3 hours a week, maybe supervised, that time is called parenting time, which is the same term that's used to describe the time the child spends with the parent they live with. So these orders, what are we going to see? We might see orders that talk about primary residence. The children will be primarily resident with the mother, who shall have parenting time on the following schedule, and the father shall have parenting time. And then those times would be slotted in there. I'm not necessarily opposed myself to getting rid of the terms custody and access, but I do find it a bit odd that now we just have one term, parenting time, to describe any time a parent spends with a child, no matter how minimal that time is. Leah, are there any questions relating to what we've talked about already?
Yes, we do have one question here. So when saying that the person with sole custody cannot move, are there limits on that restriction?
Yes, there are. The parent, so that's the old language, but I just want to be clear, so it's only good for a few more days. But the parent who, if a parent has sole custody, they cannot make a decision to move if the move would interfere with the other parent's access time with the kids. So if I want to move a few blocks in my city or town, I'm supposed to let the other parent know that. But that's not going to affect their access to the child. And so they don't really have any say in that. But if I'm going to move such a distance that that Wednesday after school access that the other parent has now isn't practical, then they have to be involved in the decision, or I have to go to court to get an order. Now, I mentioned at the beginning that there are significant changes in the Divorce Act to how the relocation of children happens. I think that we should do a separate webinar sometime just on that, because it's actually a huge topic. If I had decided to put that in today's presentation, we would have needed at least another half hour. So there are big changes to how a parent can move with a child as a result of the Divorce Act, but we'll save that story for another day.
Sounds good. Thanks, Pam. I just want to remind folks that you can put questions in the Q&A box throughout at any point, and that will help us kind of get through as many as we can. So don't hesitate. Don't wait till the end. Put them in anytime.
But that's it for now, Leah?
Yes, that's it for now.
Great, thanks. Okay, let's move on to talk about the definition of family violence that now appears in the Divorce Act. The old Divorce Act made no mention of family violence in the provisions dealing with custody and access. Here, family violence is given a broad and inclusive definition, and factors are provided for how it's to be considered when courts are making parenting orders. And I think this is the single biggest improvement out of all of the changes to the Divorce Act. So as you can see from the slide, there is quite an expansive definition. The boldface is mine, that's my emphasis. It's not written like that in the Divorce Act. And what it says is family violence is any conduct, whether or not that conduct constitutes a criminal offense, by a family member towards another family member that is violent or threatening, or that constitutes a pattern of coercive and controlling behavior, or that causes that other family member to fear for their own safety or for that of another person. And in the case of a child, the direct or indirect exposure to such conduct. We're going to look at that line by line in just a minute, but before we do that, I want to share the list of behaviors that are included in that definition. So after the definition that you just saw, there's a list that says, and includes but is not limited to physical abuse, including forced confinement, but excluding any actions, any use of reasonable force that a person uses to protect themselves or another person. Sexual abuse, threats to kill or cause bodily harm to anyone, harassment, including stalking, the failure to provide the necessaries of life, psychological and financial abuse, threats to kill or harm an animal or damage property, as well as the killing or harming of an animal or the damaging of property. So we've gone from zero reference to family violence to what is probably not a definition that would satisfy all of us, but certainly a very comprehensive definition. And I think there are some elements of this that are particularly important. So if we go back to the opening paragraph, the phrase that says whether or not that conduct constitutes a criminal offense, to me is enormously important. I'm sure all of you have had the experience of assisting a woman with her family law case where she introduces copious evidence about a history of abuse, only to hear from the judge, well, you know, he was never charged, so it can't be that serious. So now when a judge starts to say something like that, the woman's lawyer, if she's fortunate enough to have one, or the woman herself can say, well, Your Honor, actually, look what it says. It says it's any conduct whether or not it constitutes a criminal offense. We know that only about 25% of women report family violence to the police. And so having this in here, I think, is really important. The reference to a pattern of coercive and controlling behavior and behavior that causes fear, I think, is just as significant as the criminal offense phrase earlier on in that sentence. Coercive and controlling abuse is the hardest to prove because it often doesn't involve anything physical. You all know what it is. I don't have to tell you what it is, but courts don't get that yet. Judges don't get that. Lots of lawyers don't get that. So as with the whether or not the conduct constitutes a criminal offense, to have this spelled out in the definition is extremely important. And then if we go back to the list, I think the parts of it that I'm the most excited would be kind of an odd word to use, the happiest to see in here are the threats to kill or harm an animal. We all understand well the connection between animal abuse and woman abuse. We know that many abusers use the pet or the threat of harming the pet as a way to keep the woman in the relationship or to keep her from leaving the home. So I'm really happy to see that in there. I'm also very happy to see psychological and financial abuse listed explicitly, because too often we hear comments in the family court process, unfortunately sometimes from judges, that really excuse me, diminish the importance of that abuse. And yet, I mean, how many of you have worked with women who've said, if only he would have hit me, it would have been easier for people to understand what was happening. I just could never get anyone to understand because everything he did was with his words. Or women who are so disempowered financially, I'm sorry, that they can't even imagine the possibility of leaving the relationship. So I think that these are important additions to the Divorce Act, and that having a definition like this at least gives us a starting point to educate lawyers and educate judges. Because I need to cough, are there any questions, Leah?
Yes, there are. So we do have a few questions here. One of them sort of refers back to, I guess, some of the language you were talking about earlier, but asking, so will these changes around like decision-making responsibility, the new language, apply to new orders moving forward only, or applied to existing court orders prior to March 1st?
Like all law, it's not retrospective, it's not retroactive. So anybody who starts a divorce case as of March 1st can rely on these provisions. Having said that, if I were representing somebody who had started her divorce application, anytime in the last 3 or 4 months when this law was passed in 2019, it's just that it didn't come into effect, or it isn't coming into effect until next week. I would certainly be making the argument that this was the intention of the government and the direction the government wanted to move. And so I would be trying to introduce these concepts, even if the case had been started before March 1st. If I got a decent judge, I think I would make some headway with that. But from a purely technical and legal point of view, the changes are only applicable to cases that start on March 1st or later.
Okay, we do have a few other questions here. So one of them is, because in the definition you talked about whether or not it's a criminal offense. So someone asking, if someone is found guilty in a criminal case, does that help at all in family court? Or
Always.
Always.
Always. And I am going to come back to that because it appears in the list of factors the court is required to consider. So I'll say more about that in a minute.
Great. And then there's two more, but I'm going to try to combine them because I think there's some similarities. Just asking about, how are they going to assess the evidence of domestic violence? Are they like using danger assessments, or would evidence from a woman's shelter, that they're in a woman's shelter or something, sort of speak to that?
And that I will come to also in a couple
Perfect.
of minutes. So great. And I think maybe I've got my voice under control, so we'll try to carry on.
Okay.
As I just said, in response to one of the questions, the legislation now sets out the factors that the court is required to consider if the issue of family violence has been raised. So if in my application for a divorce, also for a parenting order for the kids, I talk about family violence, it's now on the table. And the judge has to use these factors when deciding how much weight to give, how much attention to pay to this issue of family violence. So the court has to look at things like, what kind of abuse is it? How serious is it? How frequent is it? When does it happen? Is it increasing in frequency or seriousness? All of which would help the judge, especially if the judge is well informed about family violence, to determine whether this is something that's likely to be an ongoing issue and therefore should be taken into account. The second factor is whether there's a pattern of coercive and controlling behavior. Is the abuse directed toward a child, or is the child directly or indirectly exposed to it? What's the physical, emotional, and psychological harm or risk of harm to the child? Is there a compromise to the safety of the child or other family member? Does the violence cause the child or others to fear for their safety? So all of those focus on the impact on the child. And that's not surprising, because here we're looking at all of this in the context of a court case that's about to make a decision about the parenting arrangements for the children. This last one I find interesting. One of the factors, it says, is the person who engaged in violence taking steps to prevent further violence from happening and to improve their ability to parent? It's a great question. I think it's important in principle, but, and I think this is true right across this country, there are not adequate programs for people who engage in abusive behavior, and there's pretty limited objective systems in place to assess whether those who do participate in those programs have actually changed their behavior. So how are we going to answer that question in a meaningful way? I like the fact that it's there. I'm just concerned that we can't actually answer it properly because we don't have sufficient programming and we don't have adequate evaluation of the impact of that programming. And then the final factor, anything else that the court thinks is relevant. So you can kind of throw anything you want under there. So these questions are asked, should be asked by the judge as they're analyzing the evidence that's been put in front of them. In just a minute, as we look at the best interests of the child test, I'm going to talk about the kinds of evidence that would be helpful for a woman to put forward to support her case. And I think that will speak to some extent to those questions that were asked a few minutes ago about how the court assesses the weight of the claim that there's been family violence. So let's look at this best interest of the child test. And I really apologize for my voice, but there's nothing I can do about it. All family law legislation in Canada, this is also true in many other parts of the world, sets out the requirement that decisions about the care of children are to be made using the best interests of the child test. The old Divorce Act, the one that we still have until Monday, did just that, but it did not provide a list of factors or criteria for the courts to use when they applied that test. In the new Divorce Act, the first thing that is said about the best interests of the child is that the court is to take into consideration only the best interests of the child of the marriage in making a parenting order or a contact order. So it's just really reinforcing this principle that this is about children. It's not about parents. Parents in Canada don't have a right to spend time with their children. Children have the right to spend time with their parents in whatever way is in the child's best interests. So this is a very child-focused approach. It's also a recognition that families are unique, and you'll see how that plays out when we, in just a second, look at the factors that are part of this best interest of the child test. Every family is different. So parenting orders, as they're going to be called, have to reflect the uniqueness of those families. Following that general statement, only the best interests of the child are to be taken into account. The legislation says that the court is to give primary consideration to the child's physical, emotional, and psychological safety, security, and well-being, which clearly indicates, I think, almost as a precursor to the list itself, that the presence of family violence will be given weight in the use of the best interest test. The test has 11 criteria or 11 factors. They all must be considered. As with existing legislation, the Divorce Act and provincial statutes, there's no weight assigned to each criterion. So there's this list of 11 things, but it's not like one of those exams where you're told that question 1 is worth 5 marks, question 2 is worth 20, so you have to spend most of your time on question 2. That doesn't happen here. The judge has the discretion to give the weight that they think is appropriate to each of the factors. They should be doing that based on the evidence that is put in front of them. And you'll see in just a second how that can play out, but also how that can be difficult. Certainly, some of these factors are potentially problematic for women leaving abusive relationships, and I will flag that for you as we go through here. So let's look at these different factors. First, the court must, and all of these are must consider the child's needs, including the child's need for stability and the child's relationship with each parent and other family members and other people who play an important role in the child's life. Evidence about how the mother will create or maintain stability, as well as the child's relationship with other important people, will be critical to her case. Because, and again, I don't have to say this to this audience, the abuser is going to try to undercut everything the mother says, is going to try to make it look as though she's leaving him for no reason at all. She's holding the children away from him for no reason at all. So she needs to come out with strong evidence to say, yep, I'm leaving. Here's why I'm leaving. We'll get to that in a minute. And here's what I'm going to do to make sure that this move, this change, has as little impact on the children as possible. Here's how I'm going to keep things as stable as possible. So that could include evidence that, for example, even though she and the kids are leaving the matrimonial home, she'll stay in the same neighborhood. So the kids don't have to change school. So they can still see their friends, engage in familiar extracurricular activities, and so on. If the children are close to their paternal grandparents, it will be important for her to tell the court how she'll maintain that relationship, or if it's not safe for her to do that, she'll have to tell the court why it's not safe and what she's planning to do to replace the time that the kids used to spend with the paternal grandparents. So she builds her case by saying, yes, I'm making changes here. Here's what they are. Here's why I'm making them. And here's how I'm putting my children's best interests first. Now, if she's leaving an abuser and she can't stay in the same neighborhood, she can't afford housing in that neighborhood, or it's not safe for her to stay there, then of course she's going to move. And if the children need to change schools, the children need to change schools. But she will tell the court why and will explain what steps she's taking to minimize instability. That's the first 2 of the 11 factors. The third factor that the court's required to consider is each parent's willingness to support the child's, the development and maintenance of the child's relationship with the other parent. I'm flagging this as a factor that is of definite concern in situations of family violence. Many mothers engage in protective parenting. I'm sure you've worked with women who've done this because they have legitimate concerns about the safety of their kids when they're in the care of the father. That concern may be based on threats he's made to try to keep her from leaving him, like, you can leave me, but you'll never take my children away from me. She may be concerned because of behavior she's witnessed in the past, or maybe he's been a completely disengaged dad up until now, and there's a very young child, and she just thinks he doesn't know how to change a diaper. How's he going to take care of the kids on his own? Whatever the reasons, protective parenting can be and is interpreted as a lack of willingness on the part of the mother to support the child's relationship with the father. Sometimes it's even interpreted as parental alienation. When a mother has concerns about the safety of the children with their father, she needs to set those out in detail in her evidence to support any limitations she wants to put on their contact with him. So let's say she thinks that for now, supervised access is the only safe arrangement. She will say that, and she'll say, here are the reasons for that. He has spent very little time with the children. I'm the one who's done this, done that, done the other thing. Over the 10 years of our marriage, anytime I talked to him about leaving, he would threaten to take the children and move to another province where his parents live. Anything that she has as evidence to show that she has a legitimate concern about the children spending time with the father, she needs to put in there. And I'm afraid to tell you, she also needs to sound sincere about wanting the children to have some kind of relationship with the father, no matter how she feels about that. She can't come across in her court documents sounding vindictive or as though she is intentionally trying to interfere with the kids' relationship with their dad. But that's a problematic factor for sure. There are very legitimate reasons why a woman might not want her children spending a lot of time with the other parent because of the way that other parent has abused the mother. The court also looks at the history of care of the child. It's not uncommon for abusers to play up their past parenting role, in fact, to make up their past parenting role. A woman who anticipates her partner may do this needs to give the court a detailed description of past parenting responsibilities to support her claim that she's the one who's been the primary parent in the past. Court also looks at the child's views and preferences. The weight that's given to this factor will depend very much on the age and sort of maturity of the children. A 1-year-old's views and preferences will not be given nearly as much weight as the views and preferences of an adolescent age child. Court also looks at the child's cultural, linguistic, religious, and spiritual upbringing and heritage, including Indigenous upbringing and heritage, and will want to make sure that that is continued regardless of which parent has primary time with the kids. And the court looks at plans for the child's care. Parenting plans are now an important part of most family law cases that involve children. A woman needs to ensure that her plan is realistic and honest, especially if her abusive former partner is likely to propose plans for the children's care that are exaggerated and unrealistic. You know, the father who's never done anything with the children but comes into court and says, you know, I've hired a nanny and I'm changing my work hours and we're going to do this every weekend and on March break we're going to do that. I'm pretty suspicious about those kind of plans. History really is the best way to determine the future when it comes to parenting. We're getting close to the list of all of these factors here. Next, we have the ability and willingness of each parent to care for and meet the child's needs, and the ability and willingness of each parent to communicate and cooperate, especially with one another, on matters affecting the child. Both of these criteria can be challenging in family violence cases. To counter an abuser's claim that he's able and willing to care for the children, the woman must be prepared to introduce evidence of a lack of past parenting, as well as the history of abuse, including abuse that's happened after separation. Courts really don't get, family courts really don't get post-separation abuse. And yet I think it's probably the single most important consideration when you're looking at how parenting should be arranged. Because if this person has not chosen to stop engaging in abusive behavior even after the relationship ended, he's not going to stop engaging in that behavior once there's a court order. And the parenting order needs to take that into account. The same is true for this bottom one, the ability and willingness of each parent to communicate. That's really difficult. If I'm terrified of my partner and I've finally been able to leave the relationship, the last thing I want is to get saddled with a parenting order that says I got to chat with him all the time. And cooperate? Come on. He's not a cooperator by definition. So the woman needs to be honest in her document. She shouldn't say, oh, sure, I'm happy to do that if it's going to be unsafe for her or if she just knows it's not going to work out. She needs to raise the issue of family violence in this context. And she needs to provide detail and specificity when she talks about the impact of the abuse and why that affects her willingness to communicate and cooperate. The court must also consider family violence and its impact on the abuser's ability to care for the children, to meet the needs of the children, and also on the appropriateness of making an order requiring the parents to cooperate. And finally, and this goes directly back to one of the earlier comments, the court's required to look at civil or criminal proceedings, orders, conditions, or measures that are relevant to the safety, security, and well-being of the child. So here's where we squarely see family violence directly spelled out in the best interest test. And I think it's quite well set out here. The court has to consider it, has to consider its impact on the abuser's capacity to care for and meet the needs of the child. If there have been criminal proceedings, if there have been civil proceedings, have there been child protection issues, etc. Is there a bail order in place? Has this individual already gone to jail because of abuse? All of those are things that the court, the family court, must take into account. So Leah, can we do a 2-minute question break? I just have a couple more things, and then maybe we can have a little bit of time at the end for questions.
Sure. So we have a question about the threat of causing harm to an individual. Does that include the threat of what abuser says they'll do to themselves in front of the children, or just what they've done?
No, it would absolutely include that. So where that is something that the mother knows about, or there's even a third party witness to the father having said something like that, really important evidence.
And then the last one here, if a parent is returning to court now for a change to prior parenting arrangements, will the new act come into play on that when the judges are making their judgment?
Well, I've seen people are still figuring this out. And I've seen one article that says that the new Divorce Act is not itself a material change in circumstances. So in family court, if you want to change an existing order, you have to establish that there's been a material change in circumstance. I'm paying child support of $500 a month. I lose my job. That's a material change in circumstance. Or I suddenly start earning 3 times as much money. That's a material change in circumstance. I have primary responsibility for raising our children. I become terribly, terribly mentally ill to the extent that I'm really not able to manage my daily life. That's a material change in circumstance. But we're being told that the new Divorce Act is not in and of itself a material change in circumstance. Again, if I were representing a woman who needed to go back to change an existing custody order because, let's say, the abuser was consistently not following it in some way or another, I would try to introduce the principles in the new Divorce Act as I was arguing her case for changing the existing order. That's the best answer I can give, because it's not going to be considered a material change, but that doesn't mean a creative lawyer can't find a way to try to bring it in.
Awesome. Thanks. That's all for now.
Okay. So just a couple more things from me, and then we can have some time at the end for more general questions or comments. Maximum parenting time. The old Divorce Act, so before March of 2021, the Divorce Act specified that when courts make custody orders, they're to follow the principle that children should have as much contact with each parent as is in their best interests. This was known as the maximum contact provision, or the friendly parent rule. Those of us who are lawyers who've been working with survivors of family violence have hated this provision forever, because unfortunately it seems as though often judges stop the sentence after the word parent. So if you look at that top green box, it seems that very often judges have interpreted this provision simply as children should have as much contact with each parent, not reading on as is in the children's best interests. It's been a real godsend to abusive men and a real burden for women leaving those relationships. Very challenging, because if the woman in the past has indicated any reluctance for the children to spend time with the father, she runs the risk that the judge is saying, well, that doesn't sound like a very friendly parent. We believe in maximum contact. We believe that children are always better off when they spend as much time with each parent as possible. Unfortunately, this hasn't changed much in the new Divorce Act. The language is very similar. It says, in allocating parenting time, the court shall give effect to the principle that a child should have as much time with each spouse as is consistent with the best interests of the child. It's way more words, but it really says almost the same thing. So that concern remains in place. I would say at this point, my hope is that because there is now a very detailed best interest of the child test, there is a strong definition of family violence, it might be less onerous for mothers who need to limit or ask the court to limit the amount of time their kids spend with their father. But that's really going to require other changes, which I'm going to talk about in just a minute. I should say, and I don't want to be overly cynical, because I'm really happy to see these changes to the Divorce Act. But we need to pay attention to the fact that in British Columbia, and those of you from BC will know this, the Family Law Act there was changed in 2013, I believe. In fact, the language in the Divorce Act is almost identical, is significantly similar to the language in the British Columbia Family Law Act. And yet, folks in BC are saying we've hardly seen any change in the kind of orders that are coming out because judges haven't been well enough educated on the issue of family violence. So which is better now, federal or provincial law? It's not really a case of one being better than the other. The Divorce Act applies only to married individuals who are seeking a divorce. So the changes to the Divorce Act make it much better than it was before. But if you're not married, or if you're married and you're not applying for a divorce, it doesn't apply to you. That means there are tens and tens and tens, hundreds of thousands of women in this country who cannot use the Divorce Act. They can't use these nice new provisions that are in there. Where are those women left? It depends to a large extent on what province or territory they live in. As I just said, BC's Family Law Act has used the language of the new Divorce Act for several years. Ontario just passed changes to its provincial statute, the Children's Law Reform Act. They come into effect also on March 1st. And so now the Ontario law is exactly the same as the Divorce Act. So that means that, at least in British Columbia and Ontario, if I'm married or not married, I can use either the provincial law if I'm not married, or the Divorce Act if I am, and I have access to the same legal regime. But the legislation in many jurisdictions in Canada continues to use the terms of custody and access. Many of these statutes make little or no acknowledgement of family violence in their provisions dealing with post-separation arrangements for kids. And so women in those parts of the country are at a distinct disadvantage because they've got no legislation that talks specifically about family violence and parenting arrangements for children. So let's just really quickly look at moving forward. There's a lot to think about as this new legislation comes into effect. On the to be concerned about front, as I talked about, the language related to decision-making presents challenges. The expectation that women will, even when there's been abuse, encourage a close relationship between their kids and their ex-partner is troubling, as is the expectation that women will communicate and cooperate with the abusive former partner. What could make it better? What could have been done so it would be better now? I wish there was less focus on alternative dispute resolution in the legislation, and I would have really liked it if it had included mandatory family violence screening by family law lawyers. So what can we do about it? Well, you folks working on the front lines are in a unique position. You can collect data over the next years about your clients' experiences as they use both the Divorce Act and your provincial or territorial statutes. Especially, are judges referring to the new provisions? Do they accept family violence as a fact more than they used to? Are lawyers approaching these cases any differently? And what kind of language are judges using in their decisions? Are they talking about family violence, or are they masking it as high conflict? At the end of the day, the changes to the law are a really important first step in moving in a good direction in family law. But there has to be mandatory education for judges. Absolutely has to be, so that they understand what family violence is and the impact it has for so many years after the people separate. There has to be accountability in judicial decision-making. Lawyers need more education. There has to be a proper legal aid regime in place right across the country so that we don't have a situation as we do in Canada right now, where more than 60% of people in family court are there without any legal representation. So the law is a good start, but on its own, it's not the answer to the problem that so many of the women you're supporting are facing. So, Leah, we have a few minutes. Are there a couple of questions we can tackle?
For sure, yeah. So one question here is about if a threat, so if a third person or overhears a threat when the victim isn't present, or a threat is made in a public place and there are witnesses, could that be taken into consideration for family violence in the court?
Yeah, it would have to come before the court in a proper manner. So if I'm that person and I'm in a shopping mall and I hear some guy, threatening to harm his children or saying something to the children like, I'm really going to get your mother for this, and what I know who the family is, I could certainly let the woman know that I had heard this. I'd have to be prepared to complete an affidavit and potentially, if the case goes to a trial, potentially testify in that trial and be cross-examined. But absolutely, third-party evidence is very relevant. It's more useful when it comes from so-called objective people or strangers. So if my sister offers an affidavit saying that my husband has treated me terribly, you can see the judge will take that less seriously than, let's say, if it were my husband's sister who offered the same evidence, or a coworker or somebody who witnessed something on the bus, because my sister would be seen to be biased. But certainly third-party evidence is very helpful.
Okay, and the last question we have up here right now is, would it be in the best interest of women who can pursue a divorce to do so while pursuing custody and access?
I think that really depends where the woman lives. If she wants a divorce anyway, if she can afford it, because it costs money to get a divorce, whereas it doesn't cost money to use provincial laws to get a parenting order. So if she wants to divorce anyway, if she can enforce it, and especially if she lives in a part of the country where the provincial law is not as good as the Divorce Act, I'd say, yeah, sure.
Okay, perfect. And just a clarification, I think, on your previous answer, would a threat of violence made by a third party, like a friend of the abuser, be considered in the family violence screening?
I don't know that I know the answer to that question, because I think it would depend on a whole lot of factors. I mean, is this somebody who would have themselves access to the children or the spouse, the victim of the abuse, the survivor of the abuse? In which case, yes. Is that person being used as a mouthpiece by the abuser? So maybe there's a bail condition that says the abuser can have no contact with the former partner. And the brother or sister or mother is conveying a message, you better watch out because ... Yeah, I would say in that case, that would be evidence that the family court should be made aware of. And I would think most judges would pay attention to that. So one of the problems about answering a lot of questions relating to family law is that they're so fact dependent. They really depend on the circumstances of a particular family. So it's sometimes hard to give a universal answer to that kind of a question.
Wonderful. Well, it looks like we've gone through all our questions just in time.
That's great.
Yeah. And if any more come in the next minute or so, like Pam said at the beginning, I will take note of that and will provide sort of a follow-up answer by email. But I just wanted to say thank you, Pamela, for that wonderful, wonderful presentation. And yeah, thanks to everyone for joining us, for your questions. Thank you to the interpreter for the work you've done making this available to everyone. And just a quick reminder for folks, we will be sharing any follow-up answers, the PowerPoint, the recording. When you log out, there will be a feedback form. So do feel free to fill that in. It helps us continue to improve our webinars. Yeah, so thank you so much, Pamela.
Well, I thoroughly enjoyed myself. I don't know what that coughing fit was about. I don't have COVID. And if I did, I don't think you can catch it through Zoom. Uh, but I apologize for that. But I had a really great time. And you folks do amazing work. If, as the Divorce Act starts to come into effect, other questions come up, feed them to WSC, and I'm happy to take a kick at trying to answer some of them.
That's amazing. Thank you so much. So have a great rest of your day, everyone. Thanks for joining us.
Bye bye, everyone.
Bye.